Hello students, and welcome back to Political Science 1513, American Federal Government. I'm your instructor, Connor Alford, and in this video I'm going to begin to explain the Judicial Branch. We'll talk about what the Judicial Branch is, how it is structured, and what it does. And then we're going to narrow the scope a little bit so that we can focus on a particularly important part of the Judicial Branch called the Supreme Court. We'll discuss how the Supreme Court fits into the broader mission and structure of the Judicial Branch as a whole, and we'll talk about how justices on the Supreme Court go about making decisions and issuing rulings. Towards this end, we've got a series of 6 learning objectives that you should focus on as you begin to take your notes and move through lecture. The first learning objective asks for you to summarize the main function of the Judicial Branch as a whole. The second learning objective asks for you to explain the concept and significance of judicial review. The third learning objective asks for you to describe how the Judicial Branch is structured, and the fourth learning objective asks for you to distinguish between the main types of jurisdiction and the different types of court that hold them. The fifth learning objective asks for you to describe the procedures of the United States Supreme Court, and finally, the sixth learning objective asks for you to identify the main factors influencing how justices rule and to describe the main forms of jurisprudence or judicial philosophy, as well as the different theories of constitutional interpretation that inform and influence these decisions by the justices. We're going to begin by looking at the Judicial Branch as a whole. So in this segment of lecture, I want to provide an overview of the structure and function of the Judicial Branch. I want to talk about the 3-tiered hierarchy of courts in our country. I want to familiarize you with the dual court system, and I want to talk a little bit about the concept of jurisdiction and the different types of court that hold the different types of jurisdiction. Okay, so what is the Judicial Branch? Well, the Judicial Branch is that organ of federal government constitutionally vested with the power, with the duty of resolving disputes about the law. You can contrast the Judicial Branch with the Legislative Branch, which creates the law, and the Executive Branch, which administrates or executes and enforces the law. The Judicial Branch adjudicates. To adjudicate is to act as a judge, and to act as a judge is to serve as a mediator of disputes about how the law should be interpreted or applied in a particular case or controversy. Now, one really important thing for you to keep in mind is that in order to resolve disputes about the law, it is necessary for the Judicial Branch to have some authority to tell us what the law does and does not say. I cannot tell you whether your activities are illegal, prohibited by law, if I cannot interpret or read that law and then tell you what it does and doesn't say. So sometimes you'll hear instructors or professors at other universities tell you that the Judicial Branch is there to interpret and apply the law, and that's correct, because resolving disputes about the law is interpreting the law and applying it to particular cases. So no, the Judicial Branch does not have the power to create the laws. That, again, was given by the framers who wrote our Constitution to Congress, to the Legislative Branch. But it does have the power to tell us what those laws say and how they should be applied in particular cases when people have disagreements about those applications. And this is really important because it helps lead into our discussion of a critically important concept called judicial review. Judicial review, I want you to understand, is the power of the courts, and in particular the Supreme Court, to resolve disputes about the constitutionality of a law or government action. I'm going to say that again because this is really important. Judicial review is the power of the courts to resolve disputes about the constitutionality of a law or other government action. Now, it is worth noting that judicial review was never explicitly mentioned in the Constitution. The Constitution did not give the courts the power of judicial review. They took it for themselves in 1803 with the United States Supreme Court ruling of Marbury versus Madison. However, if you complete your reading for this week and all of the concomitant graded components of your performance in this course, then what you're going to discover is that while they didn't get around to including the term judicial review into the Constitution, there were at least certain framers that had judicial review in mind when they created the judicial branch of our federal government with Article 3 of the Constitution. And this, you should understand, was a mechanism in their mind by which the courts could check the other branches of government. And so what we're going to discover is that judicial review is a critically important concept. It is really significant for at least three major reasons. Number one, judicial review is really important because this is the primary tool that the courts have to check the actions, power, and influence of other actors in government. If, for instance, Congress were to create a law that the courts did not like, how would they go about curbing that law? Well, they would rule that the law was a violation of the United States Constitution using judicial review. So judicial review is significant first because it is the primary tool by which the courts check other branches of government. Judicial review is important secondly because it opens the door to what we call judicial activism. Judicial activism is a particular judicial philosophy or theory about the appropriate role of the courts in our country, but we'll talk about that in greater depth at a later time in this lecture. For now, just understand that judicial review makes judicial activism possible, and we'll elaborate on what that means subsequently. Finally, I want you to understand that judicial review is significant because it makes the courts extremely powerful. Indeed, what we're going to discover is that the courts today are arguably the most powerful organ of the entire federal government. And this is true in spite of the fact that the framers had originally expected that the judicial branch would be the weakest branch of the federal government for a variety of reasons that will be elaborated on as you go through the excerpts from the Federalist papers that you need to read for this class. The bottom line, however, is that in our country, the Constitution is the supreme law of the land. And by granting themselves the power of judicial review, the power to resolve disputes about the constitutionality of government actions, the courts have established themselves as the final arbiter of what the Constitution says and does not say, and how these principles apply to particular cases. So in theory, the Constitution is the supreme law of the land, but after Marbury versus Madison, it would be just as accurate to say that in practice, the Constitution, as interpreted by the courts, is the supreme law of the land, and therefore the courts themselves do in fact have the ability to dramatically change the laws and create new rules governing day-to-day life in our country through the use of judicial review. And that was not originally foreseen by the framers who wrote our Constitution. Okay, so now we've talked a little bit about what the judicial branch is, and we've talked about its broad function as well as the core concept of judicial review. The next thing that we need to discuss is how the judicial branch is structured and organized. Now remember from prior lecture that generally speaking, if you want to get a blueprint of the organizational structure of the United States federal government, you need to look at the Constitution, and in particular at the main body of the Constitution, because those 7 articles of the main body are where the framers wrote down their ideas about how the United States federal government should look, operate, and be structured or organized. In this case, the framers discussed the judicial branch in Article 3 of the Constitution, which I've asked you to read for this class. But if you've done your reading, what you're going to find is that while Article 3 does tell you a little bit about the judicial branch, it's actually really vague. The first section of Article 3 basically tells us that there will be a judicial branch, and that the judicial branch will be comprised of one Supreme Court and whatever other courts Congress shall from time to time ordain and establish. So that means that the only portion of the entire judicial branch that is directly mentioned in and created by the Constitution is the Supreme Court. Every other court in our country has been created through acts of Congress and other lawmakers over time. And this was done more or less as the need arose. The Constitution didn't give Congress any general guidelines or directions about how to organize and structure the judicial branch as they went about creating other courts, as they went about adding to the judicial branch. And as a result, there's no clear plan or course of action. So now there are a very large number of different courts operating at different levels in government all across our country, and it can be really confusing and hard to make sense of it. However, what you're going to find out is that while the structure of the judicial branch was kept intentionally vague by the framers in order to avoid creating unnecessary debate over the minor details of day-to-day operation, there are some organizational principles which have developed over time in our country and which have helped to structure the organization of the judicial branch. The two major structural features or characteristics, the two major organizational principles that we can use to make sense of the court systems created in our country over the years are listed on this slide as the dual court system and the three-tiered hierarchy. The dual court system is a judicial structure employing independent courts operating at local levels in the states and at the federal level. It is called the dual court system because dual, of course, is two, and we have independent court systems operating at two different levels of government. One court system is going to operate at the state level, and another court system is going to operate at the federal level. What that means is that really we've got at least 51 different court systems operating in our country, one for each of the states and one for the federal government. So there is a court system in Oklahoma that deals with disputes about Oklahoma laws in Oklahoma. And there's also a court system in Texas, which is independently resolving and mediating and adjudicating disputes among Texas citizens about Texas laws in Texas. And then there's a federal court system, which has some authority all across our country, and which is mediating and resolving and adjudicating disputes about federal laws. That's the dual court system. The next major organizational principle which helps to structure and organize our judicial branch is its three-tiered hierarchy. I want you to understand that in the judicial process created for our country, there are really three different levels or stages. There are three different levels of courts. There are trial courts, circuit courts, and then there's the Supreme Court. At the very bottom level of this three-tiered hierarchy are what we call the trial courts. They are called trial courts because these are the courts that hear any particular case first. So think of it as a free trial. Why would you sign up for a free trial to Netflix? Well, so that you could make an initial assessment, so that you could test out the service and decide what you want to do with it. Do you want to pay for the subscription or not? Trial courts work the same way. They hear a dispute, they accept a case, a disagreement about the law, and they make an initial decision. The trial courts are sometimes called district courts because each one has jurisdiction over disputes about the law originating in its own district. There are 94 different districts across the entire country, and therefore we have 94 district courts, each of which handles disputes in its own territory. So the 1st District Court handles disputes about the law which originate in the 1st District, whereas the 94th District Court resolves and mediates and adjudicates disputes about the law which originate in the 94th District. But one step up from the trial courts are what we call circuit courts or appellate courts. Appellate courts are sometimes simply called courts of appeals because these circuit courts don't hear any cases until after they have already gone through a trial court. In other words, the purpose of a court of appeals is to hear, to mediate and resolve disputes in which somebody is challenging a trial court's ruling. The 94 district courts of our country are organized into 13 larger districts called circuits. And each of these 13 circuits has its own circuit court, which helps to hear, to process appeals challenging the different district courts within their circuit. So for instance, if you have a dispute about the law in California, and you go to a trial court, and the trial court rules against you, you can appeal that decision and go up one step. You can go over their head to the circuit court with jurisdiction over appeals originating in California. And as you can see on this slide, that would be the Ninth Circuit Court, because California is in the Ninth Circuit. So all of the district courts in California, Oregon, Washington, Idaho, Alaska, so on and so forth, all of the district courts which fall within the boundaries of the Ninth Circuit are under the Ninth Circuit's jurisdiction. And what that means is that if you want to challenge a ruling of one of those district courts, you would file an appeal to have your case taken over their heads to the Ninth Circuit Court. And by the way, an appeal is just a particular type of dispute about the law. In an appeal, you are disputing the trial court's interpretation of the law and going over their head to see whether the circuit court will agree with your idea about how the law should be interpreted and applied, or whether the circuit court will agree with how the district court felt and decided the law should be interpreted and applied. But we're not done yet, because there is still one final step in this three-tiered hierarchy, and that's the United States Supreme Court. If a trial court rules against you, you can appeal and take your case to the proper circuit court, which can reevaluate and either uphold, overturn, or modify the trial court's decision. But if you lose again, if the circuit court rules against you and upholds the trial court decision that you were appealing to have overridden, then you have one final, last-ditch option, and that's the Supreme Court. You can appeal again, just as you went over the trial court's head by appealing to a circuit court. If you don't like the ruling in the circuit court, you can appeal and take your case to the United States Supreme Court, which is a very special and important part of the United States Judicial Branch. By the way, if you're beginning to wonder, as you should be wondering, how to figure out which of these different types of courts your particular disputes about the law would go to, you're beginning to think about an important concept called jurisdiction. Jurisdiction is the power and authority of a court to hear a case and make legally binding decisions or issue legally binding rulings which resolve the disputes in those cases. Right? So again, jurisdiction is the power of a court to hear a case and issue a ruling resolving that case. And if you don't know, a case is simply a dispute about how the law should be interpreted or applied to a particular case that has been brought to a court. Different courts have different types of jurisdiction. So for instance, one type of jurisdiction that you might be familiar with is criminal jurisdiction. Criminal jurisdiction is the power and authority of a court to hear a criminal case and issue a ruling about how to resolve a criminal dispute. So for instance, if you have a dispute wherein the state of Oklahoma believes that you are guilty of a crime and you say that you are innocent, then your case would fall under criminal jurisdiction and therefore you would go to a court of criminal law. However, in addition to criminal jurisdiction, there is another type of jurisdiction called civil jurisdiction. And civil jurisdiction is the jurisdiction to hear torts or civil cases. Civil cases or torts are basically lawsuits between two citizens. So for instance, if you went to a grocery store and you slipped because the store owner and operator had mopped but forgotten to put out wet floor signs, you might feel entitled to compensation for the money you spend receiving medical care to help treat you for the injuries you sustained during that fall. But the store owner might disagree and say that no, he or she is not responsible for your medical bills and you should have watched where you were going. And that's a dispute about the law between two citizens. If you find yourself in this type of position, then you can file a lawsuit taking your dispute to a court and asking the court to decide whether this individual should in fact be ordered to pay your medical expenses or not. So it is important to understand that there are many different types of jurisdiction. One distinction is that between criminal and civil jurisdiction. But for our purposes, it is really important for you to understand the difference between state and federal jurisdiction on the one hand, original and appellate jurisdiction on the other. So let's start with that first distinction. State jurisdiction is the authority of a state court to hear cases involving disputes about state law and to issue rulings resolving those disputes. Whereas federal jurisdiction is the authority of a court to hear cases and make legally binding rulings resolving disputes about federal laws. If you fall under state jurisdiction, you go to a state court. If you fall under federal jurisdiction, you go to a federal court. How do you know whether your particular disagreement falls under state or federal jurisdiction? Well, in order to figure this out, you have to ask yourself 3 questions. Does your case involve a federal question, a diversity of citizenship, or a lawsuit between 2 states? If you said yes to any one of these questions, then you automatically go to federal jurisdiction, and therefore your case will be heard by and resolved in a federal court. But if you've said no to all 3 of these questions, then you fall under state jurisdiction, and you're going to a state court. So what is a federal question? A federal question is a question or dispute that has to do with a federal law or federal government actor's actions, and these federal laws are going to include the Constitution, acts of the United States Congress, and treaties ratified by the federal government. So again, a federal question is a question or dispute that has to do with any federal law. And if you have a federal question, you always go to federal court. But even if you don't have a federal question, it is still possible to get to a federal court if you have either a diversity of citizenship or a lawsuit between 2 states. Now, a lawsuit between 2 states is pretty obvious. If Oklahoma decides to sue Colorado, then that case would not go to a Colorado court, because Oklahoma can't trust courts in Colorado to be fair to Oklahoma. Conversely, it's not going to go to an Oklahoma court because Coloradans can't trust Okie judges to give them a fair shake. So in cases where states are suing each other, we always go to the federal government, because remember that we don't just want the government to mediate our disputes about the law, we want it to do so in a fair and impartial manner. And that's a part of why we rely on the courts, because at least in theory, they don't have a dog in the fight. And that's only going to be true in a state versus state lawsuit if the case is taken away from the courts of either state. But what about a diversity of citizenship? Well, a diversity of citizenship is the condition that exists in a case when the parties to the legal dispute being considered are from different states. So, for instance, if an Oklahoma citizen traveled to Texas, slipped and was injured in a store in Texas, and then filed a lawsuit against the owner of that store who was a Texas citizen, we would say that there is a diversity of citizenship, because this case involves citizens from more than one state. The Okie cannot trust Texas courts to give him or her a fair shake, and the Texan can't trust Okie courts to be impartial either. So when you have a diversity of citizenship, you go to federal courts for the same reason that you go to federal courts when your case involves a lawsuit between 2 different states. So there we have it. These are the 3 major ways to determine whether a case goes to a federal or state court. All cases involving any one of the following, a federal question, diversity of citizenship, or a state versus state lawsuit, automatically goes to a federal court. All other cases go to state courts. So now that we've talked a little bit about how the court system is structured, and we've talked a bit about the different types of jurisdiction, let's begin to talk about the different sorts of court that hold these different types of jurisdiction. And again, we're going to focus on the distinction between original and appellate jurisdiction. Because it's pretty obvious, I think, that criminal courts hold criminal jurisdiction, whereas civil courts hold civil jurisdiction. And it's pretty obvious that state courts have state jurisdiction and federal courts have federal jurisdiction. But it is not quite as obvious to say that district courts or trial courts have original jurisdiction, whereas circuit courts have appellate jurisdiction. This is the third and final distinction that you need to make in figuring out what sort of court has the authority to accept your case and issue a legally binding decision mediating the dispute in your case. If your case has never been heard before, it is under original jurisdiction and will therefore go to a trial court or a district court, because original jurisdiction is the power of a court to make an initial ruling and hear a case that has not been previously considered by any other court. And 9 times out of 10, 99 times out of 100, these types of cases go first to a district court, because district courts have original jurisdiction or the power to make an initial ruling in a particular dispute about the law that has not been considered by any other court. But what if you don't like the decision that the district court with original jurisdiction over your case has made? Well, remember, you can appeal. You can take your case to a court with appellate jurisdiction. Appellate jurisdiction is the power of a court to reevaluate and either uphold, modify, or overturn a prior decision issued by a lower court in that case. So if the district court has ruled against you, but you think they made a mistake, you can appeal to a court of appeals, to a circuit court, which has appellate jurisdiction. So understand that appellate courts have appellate jurisdiction, but they do not have any original jurisdiction. They are strictly appellate courts. And what that means is that in the circuit courts, you never see a case that has not already gone through at least one other court. The courts of appeals only review prior decisions. So courts of appeals have no original jurisdiction, they only have appellate jurisdiction. Contrast that with the district courts, which have original jurisdiction, but no appellate jurisdiction. And contrast it with the Supreme Court, which is unique in a number of ways. One of the ways that the Supreme Court is unique is that it is the only federal court which has both appellate and original jurisdiction. The original jurisdiction of the United States Supreme Court, you should note, however, is extremely limited. It is created by and given to the court by the Constitution. But the Constitution specifies that the Supreme Court will only have original jurisdiction, the power and authority to hear and resolve a dispute about the law before it has been considered by any other court in cases, number 1, which involve foreign diplomats, or number 2, involve the federal government suing or in a dispute with the state, or number 3, involve disputes between 2 or more states, or number 4, involve a diversity of citizenship, or number 5, involve a lawsuit between a state or foreign country. And this isn't really a very big list. So the Supreme Court's original jurisdiction is very secure because it's been defined by the Constitution and can therefore only be taken away through a constitutional amendment. But it is also very limited, because if the Constitution doesn't give the Supreme Court the authority to hear a case, it does not have original jurisdiction. Instead, it can only hear that case under appellate jurisdiction on appeal. And Article 3 of the Constitution tells us that in addition to the original jurisdiction, the Supreme Court shall have appellate jurisdiction over all other cases with such exceptions and regulation as Congress shall create. In other words, the Constitution says the Supreme Court has original jurisdiction in a very limited number of very specific types of cases, but that it also has appellate jurisdiction defined by Congress. This opens the door to a mechanism of checking the influence of the courts called jurisdiction stripping, because 99% of the cases that the Supreme Court is going to hear are going to need to be heard under appellate jurisdiction. And its appellate jurisdiction is defined by Congress. So jurisdiction stripping is when Congress yields its constitutional authority to limit the Supreme Court in the types of cases that it is allowed to hear. And if the Supreme Court does not have the jurisdiction to accept a case, it cannot issue a ruling in that case. And if it cannot issue a ruling in a case, say challenging a law created by Congress, then it can't rule that law created by Congress as unconstitutional. So jurisdiction stripping, at least in theory, is one way that Congress can check judicial overreach if the courts start abusing their authority or start trying to use their powers as mediators of disputes about the law to instead administrate or create the law. I will briefly note, however, that by and large, Congress does not use jurisdiction stripping. Constitutionally, it has the authority to do so, but it is extremely rare for Congress to actually try to limit the Supreme Court in this way. So while the original jurisdiction of the Supreme Court is very secure and limited, the appellate jurisdiction is less secure, but essentially unlimited, extremely expansive. And that, then, allows us to begin to focus specifically on the Supreme Court. Now, we've already kind of started this, but now we're going to narrow the scope. We're going to talk about what the special function of the Supreme Court is within the broader mission of the judicial branch, resolving disputes about the law. And we're going to talk about how the Supreme Court goes about fulfilling this function. So, within the broad mission of resolving disputes about the law, I want you to understand that the Supreme Court has two special parts to play. Number one, the Supreme Court makes final decisions. You can challenge the decision of a trial court by going to a circuit court. And you can appeal the decision of a circuit court to the Supreme Court. But if the Supreme Court rules against you, well, tough luck. There's no higher court that you can appeal to. The Supreme Court is the only court in our entire country that has final authority, which is not subject to any form of review, and which cannot be overturned by any other court. The only way to get around a ruling of the Supreme Court would be to receive a presidential pardon or actually go over the court's head by amending the Constitution. So the Supreme Court makes the final decision on how to resolve a particular dispute, because there's nowhere else to go. Number two, the Supreme Court establishes national uniformity of the law by helping to resolve disputes between lower courts about how the law should be interpreted. When two lower courts, or courts of appeals, for instance, have a disagreement about how the law should be interpreted or applied, this is called a circuit split. And the United States Supreme Court is the only kind of court that can resolve a circuit split, because it is the only court that actually has appellate jurisdiction over cases that have already received a decision by a circuit court. To understand this, let's jump back to our map of the geographic boundaries of the different courts of appeals of the different circuits in our country. Remember from prior slides that the Ninth Circuit Court has power and authority to decide how to interpret and apply the law in the Ninth Circuit when dealing with appeals to decisions made by district courts in the Ninth Circuit. So, for instance, the Ninth Circuit Court could issue a ruling that says something to the effect of there is a constitutional right to same-sex marriage. And if that's the case, then this decision would apply only in the Ninth Circuit. What if Subsequently, there were an identical case in the 10th Circuit, which encompasses Oklahoma, where somebody goes to a circuit court saying, hey, I have a constitutional right to same-sex marriage that's been violated by a state law prohibiting same-sex marriage. And the district court rules against them, so they appeal to the 10th Circuit. But then the 10th Circuit says, oh no, there is no constitutional right to same-sex marriage. Now we have a circuit split, because we have a disagreement between the 9th Circuit and the 10th Circuit about how to interpret the Constitution. The 9th Circuit says that we should interpret it in such a way that it protects the ability of same-sex partners to get married, and the 10th Circuit says we should interpret it in such a way that no, it doesn't. Well, the 10th Circuit doesn't have any jurisdiction over the circuit in the 9th Circuit. And the 9th Circuit doesn't have any jurisdiction over the 10th Circuit. So they cannot mediate this dispute. The 9th Circuit cannot impose its decision upon the 10th Circuit or vice versa. And so we've got a bit of a problem here where now in the 9th Circuit, people are being treated as though they have a constitutional right to same-sex marriage, whereas in the 10th Circuit, people are being treated as though they do not. So we have some people in one part of the country enjoying rights that other people in different parts of the country don't seem to be receiving. There's a disagreement about how to interpret the law that creates a certain degree of confusion and inconsistency in the law from one part of the country to the next. And in order to resolve this problem and establish national uniformity of the law, circuit splits have to be appealed and brought to the United States Supreme Court, because the United States Supreme Court is the only federal court, indeed the only court in our entire country, that has authority over the entire United States. And by the way, I've used this example for a reason, because this is a real illustration of an actual circuit split. In the United States, not that long ago, some circuit courts had ruled that there was a constitutional right to same-sex marriage, and other circuit courts had said, no, there is not. And therefore we had a circuit split on the issue of gay marriage that was appealed to the United States Supreme Court, and the United States Supreme Court ruled in the case of Obergefell v. Hodge that yes, indeed, there is a constitutional right to same-sex marriage. Now, you don't need to agree or disagree with that decision. What you need to understand, however, is that that decision is now the supreme law, not just of the 9th Circuit or the 10th Circuit or even the 9th and 10th Circuit. That's the law nationwide, because the Supreme Court plays a special role of resolving disputes about the law for the entire country and not just for certain portions of the country, as is the case with both trial and circuit courts. An opinion of the court might be defined as a written publication of the court's decision and the position of each justice, as well as the reasoning behind these positions in a particular case. So again, the court fulfills its functions by accepting cases when there is a dispute about the law, considering those cases, and then making decisions, which they publish and broadcast to the general public with what we call an opinion of the court. Now, you need to read from your textbook. There are actually different types of opinions, and you need to be familiar with them for test purposes. But one thing I do want you to keep in mind is that because the court fulfills its function in this way, by accepting cases and then issuing opinions in those cases, its power is purely reactionary. And what I mean by that is that there are only certain types of cases where you're going to see the Supreme Court, or really any court, getting involved. So first, understand that the Supreme Court is not allowed to get involved unless it has jurisdiction. And we've already talked about the original and appellate jurisdiction of the court, so I'm not going to go into greater depth there. You can look at Article 3, Section 2, Clause 2 of the Constitution if you wanted to get a look at that. But, in addition to the requirement that the court have jurisdiction over a case, there has to be a case. And so, I want you to note that the court only hears cases only hears disputes about the law, which involve what we call a justiciable controversy. A justiciable controversy is also called a case in controversy. And a case in controversy is a legal dispute involving a real and substantial disagreement, controversy, or issue. So, another way to explain this concept is to say that the court does not hear hypothetical cases. You might have a disagreement with your friend about whether the Constitution protects a right for same-sex couples to adopt children. And that is a disagreement about the law, how it should be interpreted or applied to a particular case or controversy, but it is not a justiciable controversy, because there has not been an actual legal dispute involving a substantial disagreement over a real law that has already gone into effect and has already impacted a particular individual. So you might not be able to say, hey, my friend wants to adopt a child with his same-sex partner and he can't, that's a problem, or my friend might one day want to do so and he can't. But it's not a justiciable controversy until somebody has actually been told you can't adopt this particular child or these particular children by an actual law or government actor. Once that has happened, they can then bring a lawsuit to the courts, and the courts can accept that lawsuit. But it is not until another branch or actor in government has made a decision that has actually impacted somebody in a way that they disagree with and is meaningful that the courts can step in. So again, a justiciable controversy or case in controversy is a real current legal dispute involving an actual law that is already in effect and that has already impacted a person in a meaningful way. You should also understand that the courts will only accept your case if you, the litigant, the person bringing legal action to their attention, have standing. Standing is the right to have your dispute about the law heard in a court. And in order to establish standing, you need to show that you satisfy two conditions. First, you need to demonstrate that you were the one who was injured by the law or government action that you are trying to challenge. So, for instance, if your uncle was denied the ability to adopt a child with his same-sex partner and you felt that that violated his constitutional rights, you would not have standing because you were not the person who was injured. But your uncle could argue that he was injured in the sense that his constitutional right was violated and he can bring a lawsuit. So injuries don't necessarily have to be physical. Do note, however, that they can be physical. Think back to the civil lawsuit example I gave, where an individual was injured while shopping. If you are injured while shopping and you feel that that is a result of the neglect of the storekeeper, you can sue and you might have standing to take that case before a court of civil law and determine whether you should be compensated for your physical injury. But it might also be that somebody hasn't followed proper procedures, or it might also be that your rights have been violated. These all count as injuries, but they need to be meaningful. It cannot simply be a case of I was offended or I was inconvenienced. It cannot be a case of I broke a nail. But if it's a case of I broke a hip or my constitutional rights were violated, then you might have standing. So in order to establish standing, you have to prove that first, you have actually been personally injured, and second, that your injury is meaningful, that it is actually in some way disrupting your life or your ability to, say, pursue happiness. Well, if the court then has the jurisdiction to hear your case, and you have the right to be heard because there is a justiciable controversy and you were the litigant with standing, the next step in the process is for the court to actually accept and hear your case. But I want you to note that the court is extremely unlikely to do so. This varies from year to year, depending on factors like the political environment, but generally speaking, the United States Supreme Court is only going to accept about 1 out of every 4,000 eligible cases. And I also want you to understand that this decision about which cases they're going to accept and which cases they're going to ignore is an important part of what the courts do. Because the courts can allow, say, an unconstitutional law to remain in effect simply by refusing to accept a lawsuit challenging that law, because they know that if they accept it, they would then have to rule against it, and they might not want to. So by picking and choosing their cases, the courts do have a de facto ability to shape which laws are enforced and which laws are overturned in our country. That being said, there are certain types of cases that the Supreme Court is more likely to accept regardless of political environment. The Supreme Court is more likely to accept a case involving a circuit split or disagreement about how to interpret the law by lower courts. It is more likely to accept a case in which a lower court has challenged one of its prior rulings, and it is more likely to accept a case involving a major controversy where there's a great deal of public pressure being placed on the court to weigh in. So those are the types of cases that the court is most likely to accept. But what are the procedures that the court goes through in order to actually process a case? Well, the first step in the process by which the Supreme Court fulfills its function is to issue what we call a writ of certiorari. A writ of certiorari is a unnecessarily convoluted Latin term that basically boils down to a written invitation by the Supreme Court to have your case heard before the Supreme Court. And in order to issue this writ of certiorari, this written invitation to bring your case to the court, the Supreme Court has to satisfy the Rule of Four. The Rule of Four basically says that the Supreme Court will not hear any case unless at least 4 of the justices on the court say that they are interested. Now currently, due to an act of Congress way back when, there are 9 justices on the U.S. Supreme Court. And so you're going to need 4 out of 9 to say, hi, I am interested in that case, before you get a writ of certiorari. And if you can't get 4 of 9, well, tough luck. What if one of the justices were to retire or pass away, and your case was brought to the court before their seat could be filled? Well, then you would need 4 of 8 justices, because the Rule of Four still applies. And what this means is that the court is less likely to hear cases when the bench is not full, when there are vacancies. But if you do somehow convince them to issue a writ of certiorari, the next step in the process is for the clerks to do research. A clerk, if you don't know, is basically a legal secretary. Each justice on the Supreme Court has his or her own staff of clerks. Some of them have lots, some of them have very few, but these clerks do the grunt work. They do the paperwork. They're the ones who do the actual legal research during this second step in the process. They gather all of the relevant information, the facts of the case, the background of the parties in the dispute, and other relevant rulings from the Supreme Court, circuit courts, or trial courts across the country. They file these in reports, and each of the team of clerks sends those reports to their respective justice. Now, in conducting their research, clerks have a tendency to rely, at least in part, on what we call amicus briefs. An amicus brief is very simply an advisory opinion sent to the court by an interested third party, telling the court how it should rule and why. These are not legally binding. They are purely advisory. However, what we're going to discover is that the court tends to take amicus briefs very seriously, because by reading the amicus briefs filed by relevant third parties interested in a case who come at the issue from many different directions and on both sides, the justices and their researchers can get a more complete picture of everyone's perspective. So amicus briefs do actually have a tendency to play a big role in influencing the rulings, and just as importantly, the reasonings in Supreme Court decisions, but they are not legally binding. After legal research, the third step in the 5-step process by which the Supreme Court operates is for the case to go to oral arguments. During oral arguments, each side of a lawsuit is given a few minutes to argue their case before the court and answer any questions that the justices might have. Historically, oral arguments have been very important, but today they are mostly a formality because after step 2, the justices have already read the reports of their clerks, they've already done all their research, and most of them have already made up their mind. So oral arguments are a part of the process, but at this point it's pomp and circumstance. After oral arguments, the next step is the judicial decision. During the judicial decision, the justices get together and they have a discussion about how they should rule in the case, who they should side with and why. And then they're going to advance to the final stage where they publish their decision and the reasoning in what we call a written opinion. However, in arriving at a judicial decision, before they can publish their ruling and reasoning, the justices need to see whether they satisfy the Rule of 5. The Rule of 5 is a judicial standard, which says that in order to overturn a lower court ruling, an act of Congress, or any other government action, you need at least 5 justices to agree to do so. If there are 9 justices currently on the court, then you need 5 of 9. If there are 8 justices, you need 5 of 8. If there are 7, 5 of 7, so on and so forth. So again, when there are vacancies on the court is less able to do things like check other branches of government by ruling their actions, laws, or policies unconstitutional. Now that we've talked about the 5-step process, from the writ of certiorari to publishing written opinions, the next thing that I want to talk about are the factors which influence judicial decisions. So in this segment of lecture, we're going to begin to discuss what factors explain how a particular justice rules and why different justices tend to disagree on how to issue rulings or resolve disputes in very controversial or partisan issues. We'll talk about the concept of judicial philosophy. We'll briefly touch upon political ideology. And we've already kind of mentioned this a little bit, but time provided towards the end of lecture, we'll also talk just a little bit about how the court can be checked. So here's what I want you to write down first and foremost. There are 2 primary factors which help to explain how a particular justice will rule in any given case. These factors are that justice's judicial philosophy or jurisprudence on the one hand, and that justice's political ideology on the other hand. A political ideology is a set of general beliefs about the proper role of government as a whole. Some examples of ideologies, which we will elaborate on in subsequent lecture, are liberalism and conservatism. In our country, we have some people who are liberals and think that government should play a very big role in society, and we have some people who are conservatives and they say it should play a fairly limited role in society. There are also libertarians who say it should be even more limited than conservatives, and statists who are sometimes called authoritarians and want the government to play an even bigger role than anyone else. The bottom line, though, is that a justice's political ideologies, his or her prior conviction, his or her biases, his or her political party, these factors, these personal opinions, do in fact seem to play an extremely important role in predicting how a justice will rule. This is especially true when we are talking about controversial or partisan issues like gun control, abortion, or gay marriage. And some people are very concerned about that. Some people say that political ideology ought not play a role in determining how justices rule. But that argument itself makes a certain presumption about the proper role of the court. And therefore, we also need to talk about judicial philosophy or jurisprudence. Jurisprudence or judicial philosophy is a set of beliefs about the proper role of the court and the proper use of judicial review. So remember, ideology is the proper role of government as a whole. Jurisprudence is the proper role of the court in particular. And within that question of how the court is supposed to act, what role the court is supposed to fulfill, falls a sub-question. How should the court use judicial review? Remember, judicial review is the power of the court to resolve disputes about the constitutionality of a law or government action. And what we're going to discover is that this is where you start to see disagreement between different justices. Some justices adhere to a judicial philosophy called judicial restraint. Judicial restraint basically stipulates that it is the role of the court to be constrained to its strictly constitutional role as a mediator of the dispute. And so a judicial restraintist would say that the Constitution is a legal document. It says what it says, it doesn't say what it doesn't say. And it is the role of a judge or justice not to try to manipulate, alter, or change the Constitution to suit their own political biases or ideologies, but rather to simply follow the Constitution and use the Constitution to mediate disputes about the constitutionality of government actions. In other words, a judicial restraintist says that the proper use of judicial review is to overturn unconstitutional government actions, and that's it. If an action is constitutional, you should not overturn it, even if you don't like it. Because your job as a justice is not to legislate. That's the legislative branch. They're the ones who create the law. You're an unelected individual. Your job is simply to determine whether the rules created by Congress are consistent with the Constitution. If they're not, you overturn them. Now, they may create an unconstitutional policy that you like, but whether you like it or not is not the issue. The issue for a judicial restraintist is purely a question of whether or not the law violates the Constitution. Judicial activists, however, say it's not that simple. You can't just consider what the Constitution says or doesn't say. You have to treat the Constitution like a living, breathing document, and you need to interpret the Constitution in ways that allow you to play a more active role in checking the power and influence of other actors in government, and to actively shape the law. So judicial restraintists say we're not here to shape the law, we're here to fulfill our strictly constitutional role of interpreting and applying the law to particular cases. Whereas judicial activists say we're not here simply to apply the law, to fulfill our strictly constitutional function as mediators of dispute. We should use our power of judicial review to promote desirable outcomes in society. In other words, if I think that it would be in our country's best interest for me to uphold an unconstitutional policy, I should do so. If, on the other hand, there is an action that has been taken by Congress that is, technically speaking, constitutional, but based on my political ideology, I think it is detrimental to society, well, in that case, I should strike it as unconstitutional. So it's more a question of which policies are good and bad, and less a question of which policies are strictly constitutional or unconstitutional. And for this reason, judicial activists are sometimes called legislative activists, and judicial activism is sometimes referred to as legislating from the bench, because a judicial activist says that as a justice in a position of power, I should use my ability to engage in judicial review to promote policies that I think are good and strike policies that I think are bad, and I don't necessarily have to limit myself or be constrained by the literal meaning of the Constitution. And this actually leads us into our next major discussion, because the debate between judicial activists and judicial restraintists ultimately and often boils down to a disagreement about how to interpret the Constitution. Broadly speaking, judicial restraintists, or constraintists as they are sometimes called, believe that we should have a strict construction or strict interpretation of the Constitution. A strict construction of the Constitution is sometimes called a narrow construction or narrow interpretation. And the reason that restraintists prefer narrow interpretation is that narrow interpretation constrains the ability of an individual judge or justice to impose his or her own political ideology, values, beliefs, or biases onto the country by telling the justice that he or she needs to focus on the letter of the Constitution and what it literally says based on various rules that are outside of that justice's discretion or control. Broad construction or broad interpretation of the Constitution, on the other hand, says that justices should be free to act as judges who exercise discretion and who use their power of judicial review for the betterment of society. And therefore they need to interpret the Constitution in more liberal ways that allow them to promote positive outcomes. In other words, you interpret the Constitution in ways that suit the ends you would like to achieve. But within these categories are certain more specific theories of constitutional interpretation that are broken down in greater detail by one of the handouts available to you in this week's coursework folder. But we're going to start on the strict construction side by talking about literal meaning, or textualism. Textualism is one strict interpretation approach to the Constitution. And it tells us that in interpreting the Constitution, judges and justices should focus on the literal meaning of the words in the Constitution based on the laws of English language and grammar today. So if I need to determine whether there is a right to keep and bear arms, I will look at the Second Amendment and I will read it, and I will look at the commas and the periods and the punctuation and the spelling in the Second Amendment, and I will say, hey, based on the laws of the English language and the punctuation of this clause, yes, there is, or no, there is not a right to keep and bear arms. Closely related to literal meaning is original meaning. Original meaning says that we should focus on interpreting the Constitution based on the laws of the English language, not as they exist today, but as they existed at the time that the Constitution was written. Now, original meaning still constrains the ability of judges and justices to impose their own opinions, biases, and political ideologies on the ruling, because they don't have the power to change the definitions of words at the time that the Constitution was written, or to change the rules of the English language at the time that the Constitution was written. However, I do want you to note that original meaning does leave them a little bit more discretion, because the rules of the English language had not been standardized and imposed with as much uniformity as they are today back in the 18th or even 19th century. It took time for things like Webster's dictionary to develop, and so the rules of the English language at the time that the Constitution was written aren't as clear or available to us in as objective a manner as modern English language is. And so what this means is that in order to interpret the Constitution through the lens of original meaning, judges and justices have to do a little bit of historical research. They have to find documents that were written at the time of the Constitution in order to figure out how people understood the literal meaning of words and phrases back in the 17 and 1800s. And they can kind of pick and choose which documents to focus on or emphasize based on their own personal discretion. So original meaning is still a strict construction, but it is not as strict as literal meaning or textualism. Then we get original intent, which is, again, still strict construction, but even less so than original meaning. Original intent says it's not enough to focus on what the words in the Constitution literally meant at the time that it was written. You have to think about the intent behind their inclusion as expressed by the framers in documents like the Federalist and Anti-Federalist papers. So, for instance, the courts have told us that the freedom of press applies not just to literal printed media, but to modern forms of media that were not around at the time that the Constitution was written, including cable news, the internet, and radio. Now, literally speaking, the press refers to the printing press. And so the literal original meaning of the word press was a pamphlet, was printed media. But today, the courts have said, look, the framers didn't include the freedom of press because they were fixated on this particular piece of technology. The idea was to protect a free flow of information and ensure that the public has as much access as possible to information from sources other than the government, so that they can be aware when the government is doing things that the government doesn't want them to know about. And cable and internet and radio, they all help to fulfill this function, and so it is consistent with the original intent of the Constitution to interpret it in such a way that we are going to preserve the freedom of the press, broadly speaking, under a more modern understanding. So another way to think about this is to say that literal meaning and original meaning say that we should read the Constitution based on the letter of the law. Original intent says that we should interpret the Constitution based on the spirit of the law. Finally, we have stare decisis, which is Latin for let the decision stand. Stare decisis says that you should interpret the Constitution through the lens of precedent or prior rulings. Precedent is a fancy word for prior rulings. So if at some point in the past the court has ruled that there is a constitutional right to privacy, and you as a justice look at the Constitution and say, wait, where is that found? I don't even see the word privacy in this document. Well, that doesn't matter. The fact that the court has previously said that there's a constitutional right to privacy means that you should interpret the Constitution as protecting a right to privacy. Don't question the judgment of prior courts. And this is where you start to hear justices talking about things like the sanctity of precedent. Now, it is worth noting that sometimes the sanctity of precedent is taken more seriously by people on both sides of the aisle, more so than others. For instance, in Plessy versus Ferguson, the courts ruled that it was totally fine to impose racial segregation upon people, and they, kind of have had to make apologies for that. They've previously ruled in the case of Korematsu that presidents can unilaterally sign executive orders ordering entire racial or ethnic groups to report to internment camps where they will be imprisoned for an indeterminate period of time. These are real precedents that the court has established, and we don't tend to apply stare decisis there. But we do like to apply stare decisis when we find that prior decisions support our political preferences. Okay, so that's the strict construction approaches to constitutional interpretation. Shifting to the right side of your screen, let's now close by talking about some of the broad construction approaches. The first of the three broad construction approaches we're going to talk about is what's called polling jurisdiction. Polling jurisdiction says that justices should not only consider what the Constitution says. In interpreting the Constitution, they should first poll the empirical record by observing what sorts of policies have been implemented and successful in other parts of the world and across the country. And then they should interpret the Constitution in whatever way allows them to copy and emulate the successes of these policies. So, for instance, in determining whether to rule that there is a right to keep and bear arms, or that there is not a right to keep and bear arms, it's not enough for a judge or justice who believes in polling jurisdiction to just look at the Second Amendment and say, hey, does this say there's a right to keep and bear arms? That judge or justice has to start by looking at other countries and saying, hey, do the countries with strict gun control seem to have positive outcomes or negative outcomes? And if the judge determines, after having surveyed the policies of other countries and the successes and failures of those policies, that gun control works, then whatever the Constitution says, that judge should rule in favor of gun control. If the judge or justice finds that gun control policies tend to be disastrous, then whatever the Constitution says, that judge or justice ought to rule against gun control. So the idea of polling jurisdiction is to interpret the Constitution in ways that allow you to uphold policies that seem to work, and in ways that allow you to strike policies that seem to fail. Next up, we've got instrumentalism or modernism, which says that you need to reinterpret the Constitution in light of changing realities, technologies, and public dispositions. So, for instance, some people have justified the Supreme Court's decision in Plessy versus Ferguson to uphold government-mandated racial segregation of private businesses by saying, well, at the time, that's what a lot of people in the public have wanted. That is an example of instrumentalism. They say we couldn't do that now because public opinion has changed, and so the courts have had to update their interpretation of the Constitution to reflect changing realities and public opinion. Another example of instrumentalism that you've probably heard might sound something like this. Well, sure, literally speaking, the literal words in the Constitution protect a Second Amendment right to keep and bear arms, but at the time that that was written, they had muskets, and today we have machine guns. Therefore, in light of these changing realities and technology, the court needs to reinterpret the Constitution allowing for more gun control than would have been tolerated by the framers who wrote the Constitution, because if they don't reinterpret it periodically in light of changing realities, it will not be relevant anymore, and it won't work, and it won't be successful. So instrumentalists or modernists, they reinterpret the Constitution in light of changing realities. Finally, we've got pragmatism. The pragmatist judge or justice says that the Constitution is a living, breathing document, and you should reinterpret it in whatever way suits your ends. If you want to rule in favor of one plaintiff, then find a way to justify that decision in the Constitution. Ignore the parts of the Constitution that seem to challenge your preference, and focus in on the parts of the Constitution that support you. And those are the broad construction approaches to constitutional interpretation. I don't know where you stand on how you think judges and justices should interpret the Constitution. I don't know what your judicial philosophy is. But hopefully you found this video enlightening.